Hello everyone, and welcome to this module on arbitration under the Law of the Sea Convention. My name is Giulia Pinsauti, and I'm an assistant professor of public international law at the Grotius Center for International Legal Studies at Leiden University. Like Professor de Brabander, I'm also based in Leiden University's campus in The Hague, where I teach international dispute settlement. In the previous module, you've learned some cross-cutting concepts regarding international arbitration, such as the relevance of party autonomy and the importance of the arbitration agreement. You've also taken a journey through the history of international arbitration that has ended with the role of the Permanent Court of Arbitration in today's world. In this module, we will explore a specific type of interstate arbitration, namely arbitration in the Law of the Sea Convention. The UN Convention on the Law of the Sea, which is also commonly referred to as UNCLOS, was adopted in 1982 at Montego Bay and entered into force in 1994. Why is it so important to know and understand the main features of arbitration under UNCLOS? Well, if you follow the course of international courts and tribunals in The Hague, you may recall that Brooks Daly, the Deputy Secretary General of the Permanent Court of Arbitration, declared in an interview that UNCLOS is the biggest producer of interstate arbitration. This is not at all surprising if you think that most of the world's surface is covered by seas, and that 168 states are party to the convention as of November 2017. Thus, it is a fact that the majority of arbitral awards in interstate disputes concerns the law of the sea, and this is why our journey through the arbitration of international law disputes starts here, with the law of the sea. Can you think of an example of a dispute between two states concerning the law of the sea? What was the disagreement about? If you want, you can pause the video, take a moment to think about it, and write down the answer. When talking about disputes in the law of the sea, one thinks of disagreements over maritime delimitations. But the Convention regulates such diverse matters as fisheries, shipping, conservation of the marine environment, pollution, piracy, in addition to maritime borders. Thus, arbitration in the law of the sea is a very rich field of inquiry. Moreover, the practical significance of arbitral awards in this field is huge. Think of an arbitral tribunal drawing a maritime border or pronouncing on a state's entitlement to exploit the sea natural resources. You can readily see how arbitral awards settling law of the sea disputes can have a profound impact on the communities concerned, or on the conservation of the environment, and can contribute to the peaceful settlement of disputes. How are we going to analyze this complex subject in a clear and meaningful way? What questions will we address? One cannot understand how states use international arbitration to settle disputes under UNCLOS without looking at the full picture, that is, at all the procedures that are available under the Convention. Arbitration is one dispute settlement method under UNCLOS, but state parties to the Convention have a wider choice. Thus, we will start by mapping the various avenues that are open to states party to UNCLOS for the settlement of disputes. To give you just a little preview, these avenues include diplomatic means, the International Tribunal for the Law of the Sea, the International Court of Justice, and of course, arbitration. So, why do states choose arbitration? What are the specific features of arbitration under UNCLOS, and how do diplomatic methods, arbitration, and judicial settlement relate to one another? These are some of the questions that we will answer in the next videos. We will look at the role of arbitration in the law of the sea in particular, and then we will compare it with dispute resolution through adjudication. This course would not be complete without us looking into the famous South China Sea arbitration. In this case, the Republic of the Philippines challenged one of the permanent members of the UN Security Council, the People's Republic of China, concerning China's claim in the South China Sea. We will look at how arbitral tribunals navigate between law and politics, and what can be expected of arbitration as a means to settle politically charged disputes in the law of the sea. So let's get started.